Mr Deputy President, we live in a society founded on mutual respect, and even if it does go without saying, it is important that it is said from time to time that all people, heterosexual, bisexual, homosexual, transsexual, asexual, or wherever else one sits on the LGBTIQA+ rainbow, are respected and have the right to live their lives in freedom and not be forced to change who they are. Though this House has recognised this fact previously, it is important that we continue to work to ensure that all people of our state are accepted and respected. This bill is important, and that means it is important that we get it right. The issue with this bill, as it is with so much of what we do in this House, is the balance between competing interests. By living in society together, we accept limits on our unfettered rights, and we recognise that getting a balance point can be difficult. And so it is very disappointing that the consultation process which informed the development of this bill was so private, was by invitation only, and further that Labor used their numbers in the Legislative Council to block a committee inquiry into this bill. This is a standard process in this House. It was regarded as useful for the jury bill, and it would have been even more useful for a bill like this, which raises issues of such significant community interest, one we want to consider carefully and get right. In the consultation, I understand that there were only 2 women's groups included, but we don't know definitely because the stakeholder list is secret. And while the faith leaders may have been consulted, from the telephone in my office and from the email inbox, it is very clear that the faithful do not feel that their voice has been heard, and they have significant concerns about this bill and whether the balance of protections and freedoms has landed in the right place. We first saw this bill a week ago. Our one and only briefing was less than a week ago. I am speaking at after midnight in a debate which is unlikely to end before breakfast, because Labor chose to organise their legislative program in this way. Labor are rushing through legislation when we should be working carefully to get the balance right. It's almost as if Labor doesn't really care about this important issue, but this is a KPI they want to tick off and move on. This exclusion of the voices of the community is surprising in another way. This legislation, if I understand its intent correctly, is to make a powerful statement about inclusion and respect. This needs to be done with the community, not at the community. And there are many people who have questions about this legislation and how it will interact with freedom of religion. This bill clearly identifies religious practices as conversion practices, and then provides a rather circular exception for those religious practices which are not also conversion practices. What we see in this bill is that collision of different worldviews, which will continue to happen in a pluralist society such as ours, and which we need to approach respectfully. I think in this bill we also see a fundamental misunderstanding of the role of religion. Religion is always a call to conversion, but this is an internal call. The conversion is our personal response. We are not converted by the prayer or the preaching of others, which may serve as an invitation to convert. We are converted by our own free, willed and chosen response. Of course, we do not want people hurt by religion. We no longer live in the days of Torquemada, and we need to find a respectful balance. But this balance is only found by truly seeking to understand and respect the role of religious faith and the way in which conversion of all kinds may be part of faith. And I'm concerned that this bill does not do this. The role of religion is to challenge us, to ask us to examine our lives, to ask us how we want to live, and we want to make sure that this role is still protected under this law. It is part of the solemn duty of this Parliament always to be balancing worldviews and to ensure that people are able to pursue the good in their lives and to follow what they deem most important. For many people of our state, that includes the ability to pursue their religion. a firm belief in a metaphysical reality which forms an inherent part of their lives, one which we can never and should never try to suppress, to convert or to extract from their day-to-day lives. Religion, therefore, is a personal call to internal conversion. And here we come to another issue which I find perplexing about this legislation. It excludes the possibility that adults can freely consent. It is truly remarkable that adults are not respected by this legislation to be able to ask freely for support which they believe will be of assistance to them if that support could be construed as a conversion practice. Another major concern raised with me in relation to this bill is the inclusion of gender identity as well as sexual orientation. In many ways, this is a clumsy inclusion, as gender transition needed to be included as an express exemption to conversion practices. And the fear being expressed is that the way in which this is being done leads to only one lawful response to an adolescent querying their gender identity, that the new gender identity must be affirmed. This is problematic in many respects. The LGBAA, another group excluded from consultation by the Labor government, have made powerful submissions about the way in which gender transitioning, before a person really knows their true self, may actually be a way of what they call transing the gay away. They are concerned that too often what is described as gender-affirming care actually seeks to medically and surgically fix homosexual and autistic people who are distressed about their gender and or their sexuality. This runs directly counter to the other strong message in this legislation, that one's sexual orientation is not something which needs to be fixed. Internally incoherent legislation is never good legislation. The LGBAA continue that therapists, parents, families, educators, support workers and researchers could all be inadvertently captured by the proposed legislation, ultimately harming LGBT people who need their support. And they continue that this legislation will not only create a chilling effect on legitimate research, education, debate and therapy, but will suppress and effectively remove from the public sphere all gender-critical views. The LGBAA consider the international experience and claim that this legislation simply ignores the overwhelming evidence from the US, the UK, Finland, France, Denmark, the Netherlands, Sweden and Italy that gender-affirming care does not improve mental health or gender distress, but may in fact cause irreversible harm, including sterility. This is of significant concern, but their voice was ignored in the consultation for this bill. They are concerned that enacting a law that bans conversion practices for both sexual orientation and gender identity will harm the very group that this legislation is supposed to protect by implementing what they refer to as, and I quote, modern conversion therapy for gays, end quote. And to support their claim, they note that same-sex attracted young women are significantly overrepresented in gender clinics, with rates ranging from 80 to 90%. And they caution that by including gender identity, the proposed legislation will wrongly affirm homosexual people as the opposite gender and will impact young people who might otherwise mature into healthy, happy adults, many of whom will be lesbian or gay. And this is because they caution that embedding gender identity into law will reinforce the harmful stereotype that homosexuals are somehow born in the wrong body, suggesting medical and surgical changes as solutions for homosexuality. The successful evidence-based strategy for reducing gender distress, talking therapy or watchful waiting, will be, they are concerned, classified as conversion therapy under the proposed legislation. Research indicates that under the watchful waiting model, 80 to 90% of young people resolve their discomfort with their bodies, essentially experiencing puberty and maturing into the adult that they were always going to be, often lesbian or gay. The bill's inclusion of gender identity, they caution, deliberately limits the ability of mental health practitioners to offer alternative models of care to patients experiencing gender distress. These are important arguments about the effectiveness of this legislation from an authoritative community voice, which must be heard if this legislation is to truly affirm that not one person in our state is born broken and not one person in our state is inherently flawed. It is important that we see the whole person, and if the spirit of this bill is to assert that LGBTIQA+ persons are not born broken or wrong or flawed, then we should look seriously at whether the gender identity provisions belong in this bill alongside sexual orientation. These are real concerns which must be addressed before this bill can proceed. A serious concern that the bill will mandate an affirmative care model for gender identity, and that young adult members of families will not be able to discuss freely with health practitioners and parents issues of gender identity, and instead will only be offered an affirmation model. Nobody's born broken, but growing up can be very hard, and so often many of us feel broken, and at many other times of our lives as well. And when we feel like that, we often feel that life would be just so easy if there was just some external change that could be made. Our young people must be supported and helped through these feelings, but this legislation could create barricades against professionals and parents and others who love that young person from being able to do that. It should be amended so that it does not. Families have also raised concerns with me more broadly about the continuing ability to provide moral guidance for their children, to set family rules, and to have the robust and challenging discussions which are always a feature of successful family life. They've also raised the issue that the view of family expressed in this legislation is unduly narrow and not consistent with the reality of modern family life, especially for our called communities. Families today are much more than parents and children, and this legislation should recognise the reality of family life. The simple question I keep being asked is, can parents still say no? Or is this now a suppression practice? We need parents to be able to set limits and enforce guidelines for their children, and to do this without the forced involvement of Anti-Discrimination New South Wales. The criminal offence carries a requirement of substantial harm before an offence is committed. However, the civil redress scheme allows action to be taken for conversion practices without any proof of harm. Say a 15-year-old comes home and says they are transitioning. Their parents say, wait and see, let's see if you still feel the same way at 18. The 15-year-old complains about his parents at school, and if this, as many fear, is regarded as a suppression practice under the Act, then a complaint can be made on behalf of that child to Anti-Discrimination New South Wales. The parents then find themselves in a conciliation conference with their own child and an enforceable agreement being made between parents and children about sexuality and gender identity. Do we really believe that the law should be this active inside family life when there has been no threshold of harm that has to be satisfied? This is characterised as a civil redress scheme. Do we really believe that this is the right use of the law for children to be using the law to seek redress against their own parents? When speaking on this matter in the other place, the Attorney-General said, and I quote, "The Anti-Discrimination Board has the power to conduct investigations and inquiries relating to conversion practices. Action taken by the Board following an investigation may include education and engagement with relevant individuals and bodies." Conversion practice legislation in Victoria carries a similar provision, and the Victorian Human Rights Commission also has the power to order an individual to undertake a targeted education program at their own cost to educate them on the harms of conversion practices. These programs are provided by the Victorian Human Rights Commission and cost between $2,000 and $4,500 depending on the program which has been mandated. Again, we turn to the question of balance. Is the right balance point between protection and freedom found in this legislation? And to answer that, we have to ask, what is the proper limit of the law? and I strongly submit that it is outside the parent-child relationship. It is not including mandated education for parents in relation to their own children, and it should not limit parents setting their guidelines for children. I hope that this bill is appropriately amended before it passes Parliament. There are too many concerns held by too many people for it simply to be rubber-stamped by this chamber. Of course, passing this legislation is only one part of the process of the operation of this law. It will inevitably need to be interpreted by judges, tribunal members, Anti-Discrimination New South Wales, police and community members. And to do this, the principles of statutory interpretation, so well articulated by Chief Justice French and other members of the High Court of Australia, will be engaged, which require us to consider text, context and purpose. The second reading speech of the Attorney-General and contributions by other ministers, such as the Health Minister, provide some extrinsic context, but of course are perhaps more correctly characterised as statements of the will of the Executive rather than the will of Parliament itself. We know that Parliament's purpose is metaphorical and collective, and we know that it is often best found in the text of the legislation. But we also know that the purpose of Parliament is found by considering what was before Parliament at the time of enactment and what was Parliament's understanding of the meaning and effect of the words of the legislative text. So to assist those who will need to interpret this legislation, I want to read into Hansard extracts from a document which represents the understanding, the mind and the purpose of Parliament when enacting this legislation. It is the standard letter being sent by members of the government to those raising questions about this legislation. It forms the basis of briefings to all stakeholders and members of the crossbench, and as such represents the collective and metaphorical purpose of Parliament at the time of enactment of this legislation. And I quote, "Here is what the bill does. It protects the expression of a religious belief." And I note that this is done without limitation. So this expression in a church, in a synagogue, in a mosque, in a temple, in a school, in a preschool, in any other setting of religious beliefs, it is the intention of Parliament that it is protected in this bill. I return to the document. It protects religious teachings. It protects the expression that religious beliefs ought to be followed. It protects the right to prayer. And I note again that this is expressed without limitation. And so it is to be understood as to operate in this bill without limitation as the collective expression of the will of Parliament. I return to the document. It protects discussions between parents and their children about sexuality and gender. And I note that, of course, these discussions, as all discussions are understood within families, will be robust, sometimes challenging, but always loving and always looking to the long-term interests of that child. I return to the document. It protects the rules of religious orders, for example, the celibacy of priests. It protects general school rules, such as uniform requirements. And I note that this is, of course, in addition to and not in replacement of the broad rights around expression of religious belief and prayer, which were outlined above, and so is protective of the rights of religious schools to present a consistent and coherent message to their pupils. And I return to the document, and to be clear, this is what the bill does not do. It does not stop you from telling a young person not to have sex before marriage. It does not stop you counselling a married person not to have an affair. And I observe that clearly by implication, it does not stop the setting of guidelines and boundaries around the expression of sexual orientation. So this is what Parliament intends this legislation to mean. This legislation has excellent intentions, but needs to address serious questions before stakeholders will be confident that it will operate beneficially.
Ms. Kate Fairman.